Hello friend, in this video we're going to talk about cultural sensitivity in assessment and in family or children proceedings. First a little bit about me. I am a children law advocate with over 15 years of experience. I am doing this video to show how to properly explore cultural issues affecting the level of care a child has received or is receiving or how an assessment can be tailored to take into account the cultural issues. In this video you will see what happens when advocates or representatives for the parents have not consciously explored the impact of the cultural sensitivities affecting their client and what practical steps to take to ensure that this matter is not overlooked when the court is considering the assessment of their children's capacity to adequately parent their child or children. Unfortunately, the legal advocates and those tasked with safeguarding the welfare of the child do not always bring to the court attention the relevant cultural issues affecting the child's parents' perspective. A client may not be cooperating with the assessment purely because their cultural sensitivity has not been brought to the court's attention or brought to bear in the assessment, and no provision has been made to specifically take it into account during the assessment process. In this video, you will also see whether there is a legal obligation or a moral obligation on the court and the assessors to take cultural issues into consideration in the assessment progress. In this video, you will see the viewpoint of the local authority, the viewpoint of the expert assessors, the court's decisions regarding when it is appropriate to take into consideration cultural issues and when it is not appropriate to give it an inch of consideration. The solutions to cultural issues and their complexities would be made simple to understand and in a step-by-step format. I'm hoping that there'll be sufficient time to deal with all these matters in this video. If I find that we will not be able to deal with it in this video, then we will continue on subsequent videos, and I will encourage you to subscribe to my channel and to also give a thumbs up and share this video with others. In my experience of working as a children advocate over the last 15 years, I have read hundreds of specialist and social work assessments. I have conducted numerous court hearings to final hearings. I have observed nuances that only emerge at the final hearing. The impact of these nuances cannot be underestimated. A nuance could be how a word is understood or misunderstood by a parent or carer, and thus has affected their attitude and their cooperation during the process of the assessment. Such nuances are explained in this video, and you will see the impact of the outcome for the child or children as well. We will look at the aspect of the Children's Act 1989, which often has been overlooked, and how greater emphasis needs to be placed on the issue and when it is appropriate to do so. When the cultural sensitivities have been correctly applied or correctly taken into account by the assessor and the court, then the outcome is likely to be beneficial or more beneficial for the child. We will look at cases where cultural sensitivities have been successfully applied and other cases where they have been incorrectly applied, and they led to the court expressing lack of satisfaction with the assessment process. There will always be those who will argue that cultural sensitivities are irrelevant to assessment of children and that should not be the purview of the court. We shall address this also and other objections during the course of this video or subsequent videos. I must emphasize that there are instances where cultural sensitivity must be disregarded in the welfare interest of the child. I'm not sure whether there will be sufficient time in this video to address this point. However, it may be the case that I will consider this and some other point in subsequent videos. I think the starting point should be the Children Act. The Children Act in Section 1, we're talking about the Children Act 1989 and Section 1, subsection 1, which states that when a court determines any question with respect to A, the upbringing of a child, or B, the administration of a child's property or the application of any income arising from it, the child's welfare shall be the court's paramount consideration. By court's welfare, by the consideration of the child's welfare, I would specifically want to focus on Section 1, subsection 3, which provides for the welfare checklist. The welfare checklists are as follows. And when a court determines any question with respect to a child's upbringing of a child, the child's welfare is the family court's paramount consideration. And they include the following. 1. The ascertainable wishes and feeling of the child considered in the light of his age and understanding. B. His physical, emotional, and educational needs. C. The likely effect on him of any change in his circumstances. D. His age, sex, background, and any characteristics of his which the court considers relevant. E. Any harm which he has suffered or at risk of suffering. F. How capable each of his parents and any other person in relation to whom the court considers the question to be relevant is of meeting his needs. So these are the welfare checklists, or some of the welfare checklists, but for our purposes, subsection D is highly relevant, which is that the court has to bear in mind or take into account his age, sex, background, and any characteristics of his which the court considers relevant. And under background and characteristics, we can safely say cultural issues come to bear or should be considered as part of the child's background and any characteristics of his. Cultural sensitivities applies to people. Just to give a definition of some sort to what we are talking about in terms of cultural sensitivity. Cultural sensitivity applies to people from other cultures, including immigrants, but it's not limited to them. However, it is important to resist the temptation which links cultural sensitivity to only immigrant families, because they are culturally different within, or they have cultural differences within the various region of the United Kingdom. The point here is that there are cultural differences within the various regions of the United Kingdom. These different cultures are more apparent and conspicuous within the traveller and gypsy families. Immigrants would include people from other cultures who are yet to become accustomed to the UK traditions, customs, and values. Traveller families can be categorized to include the following: Romani or Romani gypsies, Irish travellers, Scottish travellers, Welsh travellers, Roma, circus people, boat people, fairground and show people. Thus, we can ask the question: is cultural sensitivity a relevant factor to be taken into account within the context of assessing families and children proceedings? Here, we would say absolutely yes. We are now going to examine various rulings and court decisions and indications of children and family court as to the relevance of cultural issues or cultural sensitivity. It's worth mentioning that the application of cultural sensitivities is not a new legal issue within the UK or the courts of the United Kingdom. It has long been established and considered when in other types of proceedings. And a case in point, when carrying out medical examination of immigrants, cultural sensitivity is something which law says must be considered. So it is worth noting that in immigration and asylum cases, the medical examiner are required to have regard to cultural sensitivity. In the case of MD, open brackets, Angola, close brackets, and others, on the application of against the Secretary of State for the Home Department and another, reported in 2011 in EWCA CIV from page 1238. In that case, or in this case that we're referring to, Lord Justice K, in an immigration appeal case, states to the effect that general practitioners and a healthcare team are to have regard to the cultural sensitivity appropriate when performing their duties. So it's quite clear that it's something which has been, which is regularly considered in other type of cases. Now, turning to family cases and children cases, we're now going to consider the case of an immigrant who are culturally sensitive to their 15-year-old child having a boyfriend. And that's the case reported in M-Y, open brackets, children, close brackets, reported in 2018 EWCA CIV from page 1306. In this case, the mother is a Romanian national and the father is a citizen of Pakistan. The parents were culturally sensitive to their child having a boyfriend. There were also allegations of father grooming the child. The mother's case, which we can summarize, was that the child had been telling lies about her whereabouts. The mother suspected that the 15-year-old child was seeing a boyfriend, which would have offended cultural norms in their family circumstances. The judge ordered a new fact-finding hearing in this case. In other words, the court sent this case to be retried. And I mention this case because it illustrates what happens when parents have something they are culturally sensitive about. In this case, parents were culturally sensitive about their 15-year-old having a boyfriend. We shall now look at a case involving a black woman from an African Christian congregation. And that takes us to the case of a local authority versus M, reported in 2019, EWFC, from page B21. And it involves a mother who is a black African woman and a member of a church. This case is very helpful because it states what is needed to be done to address the cultural sensitivity involved in this particular case. There is also a hint that a person could be vulnerable if cultural sensitivities are not identified and addressed. In the case, the judge states as follows: an issue that has run through the evidence merits separate attention before I turn to it. The mother is very vulnerable, or the mother has vulnerability by reason of the multiple factors to which the court has already referred, has undoubtedly disadvantaged her, and complaint is made that it was not addressed adequately or at all until November 2017. This was explored at some length, and justifiably so, by Mr. Hunter for the mother. However, it is conceded by him that there was a sea change from the date onwards, represented by the following. In other words, as the case was proceeding, the court took the view that an expert had to be appointed to look at various aspects, including the mother's the cultural sensitive issues. And the following points were observed by the judge. Number one, the appointment of a sensitive and supportive professional who not only worked with the mother but introduced her to the charity and families in care as part of the process of education, support, advice, and guidance, not least leading to a better understanding of the norm and expectation of life in the United Kingdom. Number two, the witnesses that came to speak of the mother's work with each of the charity and family in care to whom the mother is indebted and acknowledges them as considerable support both to date and continuing. Number three, the culturally sensitive PAMS assessment was another separate part of that process, and in suggesting ways in which the mother can be helped, draws attention to the difficulties that the mother is likely to have experienced to that date. Number four, the mother belongs and always belonged to a church. The involvement of families in care, in particular, has enabled members of the church, to be drawn into the process, and they are and remain willing to be a source of support to the mother. So we see in this case where the court clearly identified the benefit of having a culturally sensitive assessor to undertake the PAMS assessment of this mother. We shall now look at another case. This case is in respect to an Afro-Caribbean heritage, and it's reported as case of child 1, child 2, children care orders reported in 2014, EWFC from page B113. It provides valuable insight into some Afro-Caribbean cultural issues. So basically, the brief facts were that the mother sought the rehabilitation of the children to her care. The children have been subject to interim care orders for some time, having been removed from their mother's care for approximately 6 months after an incident when the mother accepted that she hit them outside their school. As a result of that incident, she faced a criminal trial before the magistrates on 29 January 2015 of the charge under Section 1 of the Children and Young Persons Act 1933. The children lived with foster carers initially, but then they moved in to live with their maternal aunt after spending 2 months in care. The mother was found to have slapped the children at the back of the head after school at a pedestrian crossing. The mother admitted in evidence that she did slap the girls with a wooden spoon to discipline them. She would use wooden spoon on the palm of the girl's hand, saying that she would slap child 1 4 times and child 2 2 or 3 because she is younger than child 1. The argument was then presented to the court that the assessment of the social worker was not culturally sensitive. The judge then commented in relation to the suggestion that the assessment was not culturally sensitive as follows. Miss Watkins, that is the social worker, explained to the court that it was never possible to get on to how the mother's background had affected her because the mother's angry approach to the assessment. The social worker was concerned that the children's mother did not want to answer a question. She would suggest that the assessment was not being conducted in a culturally sensitive manner. The judge, having made the final orders in respect of the children, then went on to comment on the recommendation of a specialist assessment commissioned within those proceedings, and the judge commented as follows. Prior to this, it would have been important for the children's mother to engage with therapy using cognitive analytic therapy, CAT or CAT, approach to enhance her insight into how her own childhood experiences have impacted her. I am unsure whether she would engage with this. However, I feel that using a collaborative and culturally sensitive approach, focusing on the coping strategies she has developed as a result of her experiences, would enable her to have a deeper understanding of the difficulties her children face and the potential challenge they will meet. Such an approach will assist her in responding to her children's needs now and in the future. It will be helpful if the person providing the therapy were of Caribbean ethnicity or had a good understanding of the cultural and social issues faced by the mother, as this would increase the likelihood of meaningful engagement. We'll look at a case now involving children with Hindu heritage, and also within the context of cultural sensitivity. But in this particular case, the court's approach, we're looking at the court's approach to a Hindu heritage issue involving cultural sensitivity to hinder or inhibit the social work assessment. The case is the case of F versus M, reported in 2021 EWFC from page 4. This case involved a father who was extremely controlling of the mother. This was not immediately apparent due to his coercive approach or coercive behavior. Now, in this case, the parents were Hindus. The judge emphasized the need for assessment not to be inhibited by overly anxious cultural sensitivity. It was difficult for the professional to identify the type of abuse and to be able to be more effective in their investigation. And this was because the father had repeatedly cast himself as a victim, and this was initially accepted as such by the police in particular, but also by others, including their neighbors. He caricatured the maternal grandparents as honor-based killers, although there was no evidence to support this. These allegations were initially accepted merely because the accusation was repeated in so many documents. The judge, in this case, expressed concern that the lack of challenge, in other words, the lack of being able to challenge the father's narrative, lies in the fact that the grandparents are Hindu and have brown skin. The judge said, "I am left with the impression that an overly anxious cultural sensitivity inhibited more robust forensic inquiry." In simple terms, the allegation would have gained no traction at all if a white couple had taken their daughter to a clinic for advice on her pregnancy. The visit to the pregnancy advisory clinic was the sole basis for the spurious allegation that mother's parents were honor-based killers. These ought to have been identified and the allegation discounted. That in turn might well have generated a more skeptical assessment of father. Now, this case demonstrates that a social worker must not allow cultural sensitivity to get in the way of proper child protection work and carrying out a robust assessment. We're now going to look at another case that demonstrates the same concern, that being sensitive to cultural issues must not be allowed to get in the way of investigation of allegation of harm against children. The case we're looking at is the case of P, open brackets, notice of care proceedings to father without parental responsibility, reported in 2019 EWFC from page 13. Here the court ruled that the fear of offending cultural sensitivity